Should I mention some disclosures in this video while putting it out?
Yes, nothing that I've said is legal advice, to be abundantly clear. Given that I'm like not a lawyer anymore, well, technically I'm a lawyer, but I don't act as a lawyer anymore. I'm kind of like, yes, of course, this is not legal advice.
Yes, got you. I'll put that in caps.
Exactly.
For early stage founders, right, what are some legal things that they should absolutely take care of? Well, it could be in terms of how you structure your entities, how you structure your safts if you're going to do a token, some basic framework for new founders who are just entering the space, because so many founders we've been meeting and they're like, oh, I'm scared about this legal part, and lawyers are expensive, right? And if you're just starting a company from day one, probably someone sitting in India or Vietnam might not have access to the best lawyers. So for early stage founders in the Polygon ecosystem, if you have some tips for them on the legal front.
I mean, I think first the hard part is it really is decently different based on what country you're in, right? Like in the US, there's like a very established way that like a tech company kind of like sets up. And yes, there's like differences when you're in crypto than when you're not, but like ultimately like that's the core thing, right? So like, what are the things that you want? Well, you want to set up a legal entity, like you definitely want to do that. What type of entity? Again, like going to be very different based on the country. But once you got that set up, you want to make sure that you like properly get shares issued to founders, that you properly have like agreements with the founders, right? So like you'll obviously want like invention assignment agreements that like all the IP getting created with all the employees get like put together into the entity.
Can you double click on that agreement that you just said? What is it? If you can break it down in simple terms.
So it's effectively an agreement. It's usually like it ties in like confidentiality and invention assignments. It basically says like, hey, if you create any kind of IP, you are assigning it as if you're transferring it to the company. Basically what this means is this makes sure that like the company actually owns the entire like code base or like your trademarks and stuff like that. Because if you don't do that and you're like, hey, I'm open sourcing my code base, it's like, well, you're not actually, because you don't own the code. And therefore those employees who wrote the code actually get to decide what happens with it because they actually like own it. There's counters to that in certain countries, but like the bottom line is like you want to do that. So that's like like the very, very basic things that you want to do. You want to think through, like, if you're a sole founder, it's easy. If you've got multiple founders, like, how are you going to govern the entity? Usually pretty light at the beginning, but ultimately you're going to be like, hey, I need to go raise some money now. And so, at that point in time, you're going to be like, okay, well, you need to start thinking through like some more complicated things, right? Like, do I think I'll ever have a token? Am I just selling equity? What kind of investors do I want? Those are things that you're all going to start kind of thinking through. And this is like assuming you're like pre-product even at that point in time, right? And so like ultimately, like you're probably going to sell some form of equity using a safe. Simple agreement for future equity, basically just an agreement saying, hey, I promise to issue some equity at some valuation or some discount to a valuation in the future.
Or a soft.
Or you could potentially have like a SAFT, and that's happened, like you see SAFTs very little in the US. You see them a lot more outside the US, which basically that's a simple agreement for future tokens, basically saying, hey, in the future you can actually receive tokens. And usually that like has a fixed amount of tokens or has some way of calculating the tokens. And then sometimes you'll see like a mix. There was a period of time like back 5 years ago where we'd do like, some people would do like SAFTs, like simple agreements for future tokens and equity, or equity, kind of a mess. Usually what you'll see now is like a safe plus like a warrant. And
token
effectively warrant. Like it's a warrant that gives you the right to purchase tokens at a very low valuation, like down the road. And so that's like a pretty typical structure that you see nowadays. But yeah, once you do that, now you've got like investors on board. What they usually will do is they'll have wanted to do some kind of like diligence on the company, and right? They'll want to like understand, like, do you actually own the IP? As I was saying, like who's involved? Like how much does each of the founders actually own of the company? Are they both all like still very involved in the company? They want to do a lot of that diligence. So usually when you like come out of a financing, sometimes like those really early rounds, especially in a hot market, investors like don't pay attention to anything whatsoever. When it's not as hard, they'll dig up like a bit more. But when you come out of that, you're usually in a spot where like, people have looked at it and feel like, okay, you're actually doing things like, in a
Right.
way that makes sense. And then what'll happen is like you'll get to the point where you actually like launch a product, and before that actually happens, that's when you'll already need it before the count. Like, to go through a financing without lawyers, not a good idea. So by then you should already have some kind of lawyers. But if you launch your product like prior to that or whatever, like you definitely need lawyers at that point in time to actually like go through and say like, hey, what are you doing? Like, there's some things that you can do that are so obvious from like a legal risk perspective that
Right.
like you're definitely gonna need, if you're launching any kind of derivatives anywhere, like you're gonna need some lawyers guaranteed. But like most things that you're doing in crypto, like you'll need a lawyer.
If you had to make a general checklist of documents or on the legal side of things that founders should think of, what would that checklist look like?
Yeah, I mean, I'd have to like think through all of it, but the best thing to do is like, especially in the US,
Right.
like there's a law firm called Oric. There's
Okay.
other law firms too that have these, and they have like a whole like startup set of documents.
Oh wow.
It's like
Okay.
a set of like, you'll get like a certificate of incorporation to create your entity, along with bylaws that you need, along with like a restricted stock purchase agreement to get founders stock with some kind of like vesting associated with it, along with that confidentiality and invention assignment agreement, along with some equity incentive plan, so your stock option plan, along with like the stock option agreement, or restricted stock agreement, or that's probably it at that stage. That pretty much gets you most like an offer letter, so that when you're bringing on new employees, you've got like an offer letter that goes with that confidentiality and invention assignment agreement, that ends up being like mostly the scope of documents that like an early stage company would want to like have at their disposal. When they're
what was the law firm again? Can you spell it out?
Oric is ORRICK.
Got it.
I think Perkins Coie has some too. I think Wilson Sonsini probably does. There's a bunch of law firms that have this.
As a lawyer, right, what are some blunders that you've looked at different companies do when it comes to the legal side of things in crypto that people should definitely avoid?
Yeah, wow, there's so much.
Yeah.
Most of it fits into like, I would say like the easiest one is like that whole setup that we were just talking about is like skipping it.
Okay.
And the way in which, so that's like an obvious statement, but there's also like some ways in which that happens is people being like, oh, I don't need an entity, I'm just going to go set up a DAO and like launch straight out of a DAO.
Right.
It's insane.
Right.
There are some prominent DeFi folks who like advocate for that.
Yeah.
Very, very bad idea.
Okay.
And so the answer is you should always get an entity set up. Like, you could make an argument that you shouldn't set up a for-profit entity and you should immediately set up a foundation or something like that. That way there's no equity owners and therefore you're fully aligned with like the network at all points in time. That's fine, but like the idea of like just straight up having a DAO and nothing else, fundraising out of that DAO, all that, very, very bad idea. And I've seen that like a decent amount. So I think that's like the biggest thing that I've seen. Definitely like another obvious one, like launching a protocol without like any kind of like legal advice is like a very bad idea. There's just like, especially when you're dealing in like the world of crypto, right? Where we're talking about like ideally mostly contracts that aren't upgradable, totally immutable, and now you've launched them and they can be used in, frankly, potentially any way that you allowed them to be used. Not getting advice on that's like probably not a good idea. And that's frankly maybe even more true where you do have any kind of control over it, like any multi-sig whatsoever. It's something you should have gotten like advice around. And so folks who are launching protocols without that, I think is a very bad idea. I think the financing is a big one. People are like often like, oh, I don't want to, I'm only raising $200,000. I don't want to go pay $20,000 to a lawyer or something like that. Except the thing is like, there's like an information asymmetry there that is massive, as between like a founder and like VCs. And like some good VCs are like very fair to founders, but like a lot of VCs are not. And so like when you get to like a lawyer who like does venture financings, well, now the information asymmetry might even actually lean in your favor, in terms of like a lawyer actually having market information that's just as great as like potentially an angel investor, for example. Probably not as
Right.
VC, they'll probably be pretty similar. And so like not getting legal advice on a financing is like another very big mistake. It's especially true when the
Right.
financing involves tokens
Right.
in any way whatsoever, because like legal issues around that and how that should be structured. So those are some of the things that come like top of mind that I've seen.